the basic characteristic of Malaysian Federal Constitution is the distribution of power. Distribution of power is an essential feature of federalism. Federalism means the distribution of power of the states among the number of coordinate bodies, each originating in and controlled by the Constitution.
Supremacy of Constitution. A federal state derives its existence from the Constitution. Hence, every power, executive, legislative, or judicial, whether it belongs to the nation or the individual state, is subordinate to and controlled by the Constitution. The Constitution and federal state constitute the supreme law of the land. According to Professor, were that those two institutions, the Supreme Constitution and the written Constitution, are then essential institutions to a federal government. The supremacy of the Constitution is essential if a government to be a federal.
So hi and Assalamualaikum warahmatullahi wabarakatuh. So we move to the next part, which is a written constitution. So what is a written constitution? A written constitution, also called as a codified constitution. A federal constitution must almost necessarily to be a written constitution. Definition of a federal state are complicated contracts. It will be particularly impossible to maintain the supremacy of the Constitution unless the terms of the Constitution have been reduced into the writing itself. Furthermore, they are highly popular across most countries in the world, such as the US, and most Commonwealth countries have written constitution. And same applies to countries in the Europe Union. That's all. Thank you.
Hello, my name is Shazwan Akid Bashar Nizam and my metric number is F01341. For the second question, which is identify the hierarchy of the court and its jurisdiction. Here we will start about the introduction about the court in Malaysia. First is court hierarchy. There are two, which is superior courts and subordinate courts. In superior courts, there are Federal Court, Court of Appeal, High Court of Malaya, High Court of Sabah and Sarawak. In subordinate courts, we have Sessions Court and Magistrates Court. Next is the jurisdiction of Federal Court. where number 1, original jurisdiction, to determine A. the validity of any law made by Parliament or the legislature of any state, and B. disputes on any other issue between the states or between the Federation and any state. For the second, appellate jurisdiction, to hear appeals from the Court of Appeal and the High Court. The third one, revolutionary jurisdiction, to determine any question arise before another court as to the effect of any provision under the Federal Constitution. The fourth and final one, advisory jurisdiction, the Yang di-Pertuan Agong may refer to the Federal Court for its opinion or advice as the effect of any provision of Constitution which has arisen for or appears to be likely to arise. There are 3 types of court, which is civil, sharia, and criminal.
My name is Farah Natasha binti Shah Muzamil and my metric number is F01592. I'll be talking about superior courts. So in Malaysia, the constitution set up these 3 courts, which is the Federal Court, the Court of Appeal, the High Courts, which is one for Peninsular Malaysia known as High Court of Malaya, and another one is for Sabah and Sarawak, which is known as the High Court in Sabah and Sarawak. The High Court we have, which is High Court of Malaya and High Court of Sabah and Sarawak. So the High Court in Malaysia are the 3rd highest court in the hierarchy of courts, and there are 2 chief judges in the High Court. The first is in Peninsular Malaysia, which contains 45 judges and the judicial commissioners. The second one is in Sabah and Sarawak, which has 11 judges and judicial commissioners. The High Court jurisdiction is set out in the laws made by Parliament. For example, the Court of Judicature Act 1964 stated that High Court has unlimited civil and criminal jurisdiction. So this means that High Court has the jurisdiction to decide all civil and criminal cases matter, including appeals from session courts and magistrate courts. However, the High Court jurisdiction has been limited in certain matters by other law made by Parliament. So, the power of High Court includes the power to order any person or authority to do something or to stop doing something. Second, to declare that the action of a person or authority is invalid and does not need to be followed. And the third will be order any person or authority to produce before the court people who are held in custody illegally. In criminal cases, no case may be brought to the High Court unless the offender has been committed for trial after hearing in magistrate court. So the jurisdiction to try all civil matters include bankruptcy or winding up matters, probates, and administrations of the estates of deceased persons where the amount in dispute exceeds Rm 250,000. The High Court has the jurisdiction to try all these civil matters where the cause of action occurred within the Malaysia. The Chief Judge of Malaya is the Right Honourable Tan Sri Datuk Sri Azhar bin Muhammad, and the Chief Judge of Sabah and Sarawak is the Right Honourable Dato' Abang Iskandar bin Abang Hisham. Next, we are going to talk about Court of Appeal. So, under Article 1211B of the Federal Constitution, the jurisdiction of the Court of Appeal is to determine appeal from the decision of the High Court is relating to the civil or criminal cases and any other jurisdiction given by the under federal law. So, the Court of Appeal is the 2nd highest court in hierarchy below the Federal Court, and the court is headed by the President of the Court of Appeal and constitutes up to 10 Court of Appeal judges, and every proceeding in the Court of Appeal shall be heard and determined by 3 judges. The Court of Appeal is an appellate court of the judiciary system in Malaysia and has jurisdiction to hear all appeals against any High Court decision relating to criminal matter. In civil matter, all the Court of Appeal has jurisdiction to hear and determine. The Court of Appeal has no power to review, reopen, or rehear any appeals has been made, heard, and disposed of the Court of Appeal. The President of Court of Appeal is the Right Honourable Tan Sri Rohana binti Yusof. We have the Federal Court. So the Federal Court of Malaysia is the highest judicial authority and the final Court of Appeal in Malaysia, and its decision binds all the courts below. The Federal Courts consist of a president style as the Chief Justice formerly known as Lord President. The Federal Court has the exclusive jurisdiction to determine all civil and criminal appeals from the Court of Appeal. In civil appeal, a litigant may appeal on a point of law of the rejection or admission of evidence in lower court. In criminal cases, an appeal may be made against actual or conviction or against sentence on a point of law or fact. Second, disputes on any other questions between state or between the federation and any states. And the third, any constitutional questions which has been arisen in the proceeding of the High Court but referred to the Federal Court for a decision. However, any other challenge to a law on the ground that it is against the Constitution can be brought before any superior courts. So the federal courts also hear appeals from the decision of any other superior courts. The federal court is the final court of appeal in the country of Malaysia. The federal court can also give its own opinion on the constitution when the Yang di-Pertuan Agong requests for it. So the federal court Chief Justice is none other than the Right Honourable Tun Tunku Maimun binti Tuan Mat.
Hi everyone, my name is Ellie Valencia and I would like to talk about the subordinate court. So subordinate court were established in the 1878 and it consists of session court and magistrate court. So the session court and the magistrate court have general jurisdictions in both civil and criminal matters. Subordinate court are in subordinations to the High Court and they work in the district. So the judges are appointed by the governor in consultations with the High Court. The session court has criminal jurisdictions over all offences not punishable by death and civil monetary jurisdictions over claims between 25,000 and 250,000. So the session court have unlimited jurisdiction plus one, and the parties to a legal action may enter into an agreement in writing to grant jurisdictions to the session court to try an action beyond its prescribed monetary jurisdictions. Meanwhile, magistrate court deal with minor civil and criminal cases. It may hear disputes for civil claims below 25,000. The magistrate courts may also hear appeals from the Bengkulu courts. These rural courts are presided over by the Bengkulu or the village headman and are meant for informal settlement of small village disputes. In civil jurisdiction, a session court may hear any civil matter involving motor vehicle accidents, disputes between landlord and tenant, and distress action. The session court may also hear other matters where the amount in dispute does not exceed 1 million ringgit. In criminal jurisdiction, the session court has jurisdiction to try all criminal offences except those punishable by death. Magistrate courts are divided by two, which is first class and second class. For the civil jurisdiction, in the first class, magistrate may hear a civil case when the amount in dispute does not exceed 100,000. And as for the criminal jurisdiction, a first class may hear criminal matters where the offence is punishable by a fine only. This would cover the majority of traffic offences, or where the offence provides for a term of imprisonment not exceeding 10 years. A first-class magistrate may not, however, impose a term of imprisonment exceeding 5 years or a fine exceeding 10,000. As for the civil jurisdiction, in the second class they may hear a civil case where the plaintiff seeks to recover a debt or liquidate a demand in money payable by the defendant, with or without interest, not exceeding 10,000. Where the amount claimed does not exceed 5,000, you may wish to file your claim in the small claims division of the magistrate court. If you do so, however, you must be prepared to conduct the case yourself, as legal representation is not permitted. The second magistrate may hear criminal matters where the offence is punishable by a fine only, or where the offence provides for a term of imprisonment not exceeding 12 months.
Shariah Court is a court established to sentence Muslims in Malaysia regarding Islamic criminal and civil law amid the jurisdiction and power given to them by the Malaysian federal law. Islamic law has been forced in Malaysia since 15th century before the British colonization. Islamic law has been recognized as local law and has also been acknowledged as national law since the spread of Islam to Tanah Melayu. Kings and Sultan practiced Islam and enforced the Islamic law in Tanah Melayu. Until today, kings and sultan are the official leader of the religion in Malaysia. Sharia court was established to observe the Islamic legislation to make sure Muslims obey the Islamic rules. It is also established to maintain Muslims from agitation, and it also served the purpose of solving social issues and marriage issues that occurred among Muslims. Sharia court has a quite unique function in the hierarchy of courts in Malaysia, since it sentenced Muslim. Sharia court's jurisdiction only focus on matters related to Islamic law. Hence, only Muslims are sentenced by the Sharia courts. Sharia courts are separated into three, which is Sharia appeal courts, Sharia high courts, and Sharia low courts.
Hello and hi everyone, my name is Azir bin Hasbi. In this part, we are going to explain about the related organization or institution that involved in the legal profession and its function. One of the organizations that involved in the legal profession in Malaysia is the Malaysian Bar. The Malaysian Bar, also known as Badan Peguam Malaysia in Malay, was created by the statute in 1947 under the Advocates and Solicitors Ordinance, which was later repealed by the Legal Profession Act 1976. With the motto Justice Through Law, the Malaysian Bar is an autonomous bar whose mission is to preserve the rule of law and the cause of justice, as well as to protect the legal professions and the public's interests. Malaysia's legal profession is a merged one with nearly 16,000 members. As long as an advocate or solicitor holds a valid practicing certificate, they are automatically members of the Malaysian Bar. The Bar Council is made up of 38 members who are elected every year to oversee the affairs and functions of the Malaysian Bar. The council is comprised of the Malaysian Bar's immediate past president and vice president, the chairman of each of the 12 state bar committees, one member chosen by each of the 12 state bar committees to represent it on the Bar Council, and 12 members elected by postal ballot from across Peninsular Malaysia. As March 2020, Mr. Salim Bashir Baskaran, who was formerly the Bar Secretary, was elected as president during the Malaysian Bar's 74th Annual General Meeting. There are 5 purposes of Malaysian Bar that I want to highlight in this video. The first purpose of Malaysian Bar is to uphold the cause of justice without regard to its own interests or that of its members, uninfluenced by fears or favor. The second one is to maintain and improve the standards of conduct and learning of the legal profession in Malaysia. Third is to facilitate the acquisition of legal knowledge by members of the legal professions and others. The next one is to express its view on matters affecting legislation and the administration and practice of the law in Malaysia. And the last one is to represent, protect, assist members or of the legal profession in Malaysia and to promote in any proper manner the interests of the legal profession in Malaysia. For more information about the organization, you can go to the official website www.malaysianbar.org.my.
Hi everyone, my name is Nur Atira binti Farjan, and today I would like to talk about this institution, which is the Tribunal for Consumer Claims. What is the Tribunal for Consumer Claims? Well, the Tribunal for Consumer Claims established under the Section 85, Part 12 of the Consumer Protection Act 1999, Act 599. The Tribunal operates under the Ministry of Domestic Trade and Consumer Affairs. Now, you must be wondering, who are the consumers under Act 599? Consumer means individual who acquires or uses or buys goods or services for ordinary or personal domestic consumer under Act 599, also an individual who purchases, uses or acquires goods and services primarily for business purposes. So what is the function and the objective of this institute? Well, this institute wants to provide an alternative forum to civil court consumers to reclaim redress in respect in any goods and services purchased in a convenient manner and at minimal cost. Their second function is to hear and determine claims in an independent and just manner. The third function is to develop the law on consumer protection. So, does the tribunal have the legal capacity to act on consumer complaints? Well, the tribunal is an alternative forum to civil courts for consumers to file redress claims against manufacturers, sellers or service providers for matters provided under the Consumer Protection Act 1999, and the tribunal does not have the legal capacity to act on complaints.
Hi, my name is Riddle. I'm going to talk about ASEAN Law Association. ASEAN Law Association, also known as ALA, was established in 1979. ASEAN Law Association is a non-governmental organization that brings together the Asian legal fraternity of judges, government and practicing lawyers, and also teachers of law. The objective of the organizations are first to promote close relations, cooperation, and mutual understanding among the lawyers in ASEAN countries. Second is to provide the organization a framework for regional cooperation in the study of research in the laws of ASEAN countries with a view of to harmonizing those laws are required by the social and economic development of the ASEAN region, and also in promoting and facilitating the coordination of activities and the carrying out of collaboration projects among lawyers, organizations, law faculties, legal research centers, and other like institutions in ASEAN countries, and also in promoting, exchanging, and disseminating information of the laws, legal system, and legal development of ASEAN countries, and also for the purpose of carrying out into the effect of the objectives here in before, setting it out in the publication of journals, newsletters, bulletins, and the organizations of conference meetings, symposia, seminars, and other discussions of the law. Third is to provide organizational facilities for the Asian cooperation in conflict avoidance and in the arbitration or resolution of legal disputes in transnational contracts within the Asian region, and also to cooperate with the international, regional, national, and other organizations in the furtherance of the aforementioned objective. The ALA has established standing committees to make recommendations to the governing council on matters to legal cooperation among ASEAN countries in their respective field. Each standing committee is chaired by a different member of country. For example, standing committee for international law is Brunei Darussalam, for legal profession is Philippines, for business law is Malaysia, for legal education is Indonesia, for legal information is Singapore, and for alternative dispute resolution is Vietnam.
I think that is all from me today. Thank you so much for listening. I hope you have a very good day.